Very good evening, friends. So today I'm going to discuss about the aspect of whether the income tax authorities initiate a proceeding of assessment or reassessment once the name of a company is struck off from the registrar of the companies. So before we discuss this, let us have a very brief look at the provision of the removal of the name of the company, or what it is called the striking of the name of a company from the register of the companies. Under section 248 of the Companies Act, the registrar has the power to strike off the name of a company from the register of companies, subject to several circumstances. And they are, if a company fails to commence its business within 1 year of its incorporation, or it is not carrying on a business or operation for a period of 2 years immediately preceding the financial year, and has not made any application within such period for obtaining the status of a dormant company under section 450-45 of the Companies Act 2013, or where the subscriber to the memorandum have not paid subscription which they have undertaken to pay within a period of 180 days from the date of incorporation, and a declaration under subsection 1 of section 11 to this effect has not been filed within 180 days of its incorporation, or subscriber to the memorandum have not paid the subscription which they have undertaken to pay at the time of incorporation of a company, and a declaration to that effect has not been filed within 180 days of its incorporation, and if it is found on physical verification that the company is not carrying on any business or operation, then a registrar can strike off the name of the company from the register of the companies. Now, before that striking off is done, it is important to know from the perspective of the income tax also that what is the process which is followed before the striking off of the name of a company. So before the striking off a company from the registrar of the member, a notice under section 248 is published on the official website of the Ministry of Corporate Affairs, and it is also published in the official gazette, also published in English language in a leading English newspaper, and at least once in a vernacular language in a leading vernacular language newspaper, having wide circulation in the state in which the registered office of the company is situated. And in case an application is made by the company itself, then it will be placed on the website of the company also. Now, the registrar of the companies also simultaneously intimate the concerned regulatory authorities regulating the company, like the income tax authorities, central excise authorities, service tax authorities, or now what is called the GST authorities having jurisdiction of the company, about the proposed action of removal or striking of the name of the such company, and seek objection, if any, to be furnished within a period of 30 days from the date of issue of the letter of intimation. And if no such objection is received within 30 days, then it shall be presumed that they have no objection to the proposed action of striking off. And after the company is struck off, then also the registrar causes a notice of striking of the company to be published in the official gazette in form STK2, and same is also placed on the official website of the Ministry of Corporate Affairs. So, from the perspective of the issue which we are discussing, whether once the striking off is done, then whether the whether the income tax authority can initiate any assessment or reassessment of a company which has already been struck off. So here, I think we have to understand that a company incorporated under the Companies Act is a juristic person. It takes its birth on getting the incorporation and it dies within the provisions of the Companies Act once the name is struck off. Now, the striking off may be dissolution also, the striking off may be amalgamation with another company, whichever mode it is. Once the company ceases to exist, then it is no more alive because it is a company which has died. So once any assessment is framed in the name of a non-existent entity, then it cannot be a valid legal proceeding, and one can approach the High Court for quashing of such a notice which has been issued against the company which has been removed from the registrar of the company, as there can be no assessment against a dead person. In this respect, there are judgments of the various high courts. For example, there is a judgment of the Honorable Madras High Court in the case of Pandyan Anbalagan versus Income Tax Officer, reported in 2023, 156, taxman.com, page 402, Madras High Court, and wherein it was held that once the company has been struck off, then no assessment order can be passed against such a dead company, against a dead person. Then similar view was taken by Honorable Delhi High Court, wherein it was held that the framing of assessment against a non-existing entity goes to the root of the matter, which is not a procedural irregularity, but a jurisdictional defect, as there cannot be any assessment against a dead person. And this particular judgment of the Honorable Delhi High Court was affirmed by dismissal of the SLP filed by the department. And this is a judgment wherein the civil appeal number 285 of 2024 was filed, and it was reported in the Supreme Court cases 2022-20, volume 18, SCC 353. And the citation of the Honorable Delhi High Court in this particular case is 2011 SCC online, Delhi 3210. Now here the company was amalgamated with another company. So even in the case of amalgamated company, it was held that once the company is amalgamated, then it ceases to exist in the eye of law, and there can be no assessment against a dead person. A similar view was taken by Honorable Bombay High Court, that here also the issue was that a assessment was being done against a dissolved company. The dissolution has happened in this case instead of striking off. And this is a judgment in the case of Jitendra Chandrawal Navlani versus Union of India, reported in 2024, volume 154, taxman.com, 498. So here also it was held that once the company is dissolved, then it ceases to exist in the eye of law. Therefore, it cannot be treated as a person against whom assessment proceeding can be initiated under the Act. Now, there are two further issues which arises out of this discussion, that once the name is struck off, then what is the recourse available to the income tax authority? Suppose the company has escaped assessment and the name is also struck off, then what is the avenue available to the income tax authorities? Now here, under section 252 of the Companies Act, if any person is aggrieved by an order of registrar notifying a company as dissolved under section 248, then it may file an appeal to the tribunal within a period of 3 years from the date of the order of registrar. And if the tribunal is of the opinion that the removal of the name of the company from the register of the companies is not justified in view of the absence of any ground on which the order was passed by the registrar, it may order restoration of the name of the company in the register of the companies. So therefore, if an income tax authority wishes to proceed against a company whose name has been struck off from the registrar, then it should seek revival of the company by filing a petition before the tribunal, that is NCLT, within the purview of section 252 of the Companies Act. Now herein, I would also refer to a circular which says so, and that circular was issued by the income tax department itself. The circular, one such circular is a circular file number 225/423/2017, issued by the Central Board of Direct Taxes, dated 29th of December 2017, wherein it was clarified that a large number of companies which are struck off under the under 248 of the Companies Act, the right to recover the area demand is affected, and therefore the board clarified that the jurisdictional tax authorities shall file an appeal before the NCLT for revival of the struck off company, and only after the name of the company is revived, then only they should proceed for issuance of a notice for assessment or reassessment under section 148. And there is one more circular dated 18th April 2018, wherein also it was held that once the name of the company is struck off, then the recourse available to the department is to seek the revival of the company by filing a petition before the NCLT. Now, the last issue in this connection, which is relevant to discuss, is suppose the company, this name has been struck off and a notice for assessment or reassessment under section 148 has been issued. Then what is it that the shareholder or director who were the shareholder before the company was struck off should do? One cannot sit with the folded hands, and because once the liability is fastened, then in all likelihood the proceeding for recovery of that dues which has been assessed against a company, even if it has been struck off, will be initiated against the shareholder and director, and therefore it is necessary that such shareholder or director approaches the High Court under Article 226 to get such a notice quashed. Now, one may ask a question as to what is the locus of a shareholder or a director. So here, I would like to refer to a judgment of the Honorable Calcutta High Court in the case of Sajal Datta versus Reserve Bank of India 2016, SCC Online Calcutta 485, wherein it was held that any government action which would affect the company or a shareholder, and if any individual as a shareholder or a director is affected by the action of the state, then it can file an application under Article 226 of the Constitution of India. We know that anybody whose legal or fundamental right is affected by an action of a state, then it is entitled to approach High Court to seek appropriate relief. So if any action of the government or its instrumentality causes injury to either to the company or to the shareholder or both, then shareholder or the company or both of them can approach the High Court for seeking relief under Article 226. So friends, with this, I would conclude today's session that number one, that there can be never a valid assessment against a struck off company, as there can be no assessment against a dead person. Number two, the recourse open to a income tax department is to seek the revival of the company with the purview of Section 252 of the Companies Act. Number three, the shareholder or a director can approach the High Court to get any notice of assessment or reassessment quashed. With this, I conclude today's session. Thank you very much.
Hello.
Hello.
Yes, sir. Sir, I have a query, sir.
Yes, tell me.
So the query is like uh, when a stock of company gets a notice, like say suppose 148 or 143
Correct.
scrutiny opening notice, and the company is already stock of. So you
Right.
mentioned in the first part of the your deliberation that the company should approach High Court
Correct.
being aggrieved by the notice. So my query is like whether directors should move forward or shareholders should move forward in this respect, sir.
Ideally, shareholders should move forward because you see, what we have to say is that the injury or the affected person are the shareholder, because it is ultimately, if any liability is fastened on the even a company which has ceased to exist in the eye of law, then the recovery proceeding under Section 179 of the Income Tax Act can be initiated against the shareholder. So therefore, ideally, the shareholder should approach.
Okay, so but sir, again going taking it forward, like if there is a notice and the shareholders or the directors do not do anything, and the ex party order is passed after the company is struck off, and demand is also demand notice also has been raised. So would the income tax department be able to recover from the shareholders? Like since CVDD already has mentioned that the income tax department should move NCLT and get the company revived, then only
Now, you see,
get the
at any stage, you see, what I would say that suppose, uh, no, director can also approach, because 179 fastens liability on the director also. So director or shareholder both can approach. But to answer your second question, that
yes.
what happens if the already the assessment has been made, you did not take any action while the notice was issued. So what is now the recourse to you? So my answer would be, even if the assessment has been done, since it is the assessment against a struck off company is a issue of the jurisdiction, and the issue of jurisdiction can be raised at any stage, even if the assessment has been done. Even at that stage, one can approach the High Court and get such a assessment order also closed,
Hmm.
because it is an issue of jurisdiction. Once the assessment has been done against a dead company, then the officer concerned had no jurisdiction to pass any order or issue notice. Because you see, there is a judgment of the Honorable Supreme Court in the case of, I'll just tell you, there are two judgments which I can tell you. One is a judgment of Honorable Supreme Court in the case of Commissioner of Sale Tax UP versus Sarju Prasad Ramkumar. So it is in the case of it is a matter in the context of Sale Tax Act, but the ratio equally applies in this situation also, wherein it was held that the only other contention advanced by so and so is that the SAC having not taken any objection as to the jurisdiction before the assessing authority, he is precluded from raising that objection at a later stage. This contention is unacceptable to us. Here we are concerned with the question of jurisdiction. Unless there is some provision either in the act or in the rules framed which precludes the SAC from raising any objection as to jurisdiction, if the same is not raised before the assessing authority, the SAC cannot be precluded from raising that objection at a later stage. An objection as to the jurisdiction goes to the root of the case. So it can be raised at any stage. Now, there is one more judgment which will answer your query. Is the judgment of the Honorable Supreme Court in the case of State of Punjab versus Devender Pal Singh Phullar and others. Here it was held that if the initial action is not in consonance with law, all subsequent and consequential proceeding would fall through for the reason that illegality strikes at the root of the order. In such a situation, the legal maxim sublanto fundamento cadit opus, meaning thereby that the foundation being removed, structure or work falls, comes into play and applies on all scores. So, if once the basis of a proceeding is gone, all consequential actions, orders would fall to the ground automatically. And this principle is applicable to judicial, quasi-judicial, and administrative proceeding equally.
Okay, noted, sir. So now I have another also case study from another angle.
Right.
So, sir, of late we see that corporates do a lot of transactions,
Right.
hanky-panky transactions, and once they are
Transaction, what kind of transaction you said?
like maybe share capital, raising share capital and investment. So you understand bogus kind of entries, which
Correct.
normally come under the purview of Section 68 in the income tax. So
Correct.
when they realize that maybe they have a good chance of getting notice or is under scrutiny, then they apply to the MCA for striking of a company. Once they
Hmm.
do not do the transactions for maybe a couple of years, they do a offset of assets and liabilities,
Right.
and they do a lot of write backs, write offs, and all everything
Right.
that is possible, and get it stock off.
Right.
And maybe the department comes to know a lot of these things maybe only after a couple of years, and they initiate 148. So, do you feel that there should be a harmony between Ministry of Corporate Affairs and Ministry of Finance, so that the revenue is also not at loss, and these transactions which are maybe could be liable to tax or subject to tax be identified at a stage before the company is struck off, so that the government is at no
So
loss.
there is already a harmony because I don't know whether you missed my that part of the discussion
Hmm,
that I discussed. I referred to a rule
hmm,
which is called the company's central. Sorry, the company's removal of names of the companies from register of the companies rule 2016.
hmm,
And as per sub-rule 2 of rule 7, before the striking of, the registrar of company is supposed to intimate to income tax authorities, central excise authorities, and service tax authorities having jurisdiction of the company about the proposed action of removal or striking off. So if any of these authorities has any objection before the striking off, then they can raise that objection because they can scrutinize the balance sheet of the past year, the returns files and everything, and see whether any their interest is going to be jeopardized if the name of the company is removed. Secondly, there is a circular of the income tax department itself which says that the income tax authorities should be vigilant and they should regularly monitor the website of the ROC. So if any name of the company is likely to be struck off, then they can take a remedy, the action immediately. And suppose the name of the company is struck off for this reason or that reason, the concerned officer is not vigilant enough, he does not scrutinize, even then all is not lost, because there is section 252 of the Companies Act. And after within 3 years of the removal of the name of the company from the register of the company, they can approach the NCLT and seek revival of the company. And it is routinely revived unless you see the SSC concerned is able to demonstrate before the NCLT that the income tax authority has no case against them, which is likely to result in any assessment against them. So it is not that the income tax authority is remediless even if the name of the company is struck off. And even before the striking of the company from the register of the company, the ROC is duty bound to intimate to the income tax authorities or even GST authority or any other tax authorities about the proposed striking off. And there is a public notice also in the newspaper, in the website, in the official gazette. So with all these, I mean, even if the income tax authority misses the bus, then I mean, they cannot have any grievance. And secondly, but here I think one thing I would like to point out, that in all this, you see revival and you see the action for revival and all that, it is quite possible that the timeline which is there under one section 149, which is 3 years if the escaped income is less than 50 lakh, and which is 10 years if the escaped income is more than 50 lakh. As of now, till the previous assessment year, in this budget, there is a change in that limit and the number of years for which that can be done. So let us not talk about that. But for this, there is a timeline. And one more thing, that prior to 1/4/2021, the timeline was different, uh, which was 3 years 4 years for escaped income up to 1 lakh and 6 year for escaped income more than 1 lakh. So even if suppose the revival is done and everything is done, but if the income tax authority is not able to issue a notice for assessment under section 148 within this timeline, I'm not talking about the notice under 148AB. I'm talking about the 148 notice. So I think the income tax authority has to be vigilant enough to issue notice within that timeline. Because if that timeline is lost, even if the name of the company is revived, nothing can be done. For example, you see, if suppose I approach, there is a notice against a struck off company, and I approach the High Court and that notice get quashed. And subsequently, after quashing, the income tax authorities approaches NCLT, get the name of the company revived. After that, the notice under 148 is against issued. In the meantime, it is quite possible that the timeline under section 149 is gone and the income tax authorities will be barred by limitation even if they have a very good case.
Okay, understood, sir. Thank you for enlightening. So just a last question.
Right, right.
Sorry to bother.
No, no, my
Like,
pleasure. I mean, it is good to have a very nice discussion with you.
yes, sir. So, like when we apply for liquidation to MCA or the ROC, so they ask for a NOC for from income tax department that there are no any outstanding
Correct,
dues or amount of income tax. So what I feel is like when a MCA does a so moto is struck off, or maybe someone applies for a voluntary struck off, so the MCA should also adapt this procedure while uh, striking off a company under section
correct,
240 also.
correct. I
I
agree with
think that procedure is, I am not aware that if that procedure is as of now prevalent or not. So maybe
right. I
you can
agree with
throw
you.
some
I
light on
agree with
this.
you entirely.
Okay.